Good morning, everyone. I'm Susan Hoffman, the director of UC Berkeley's Osher Lifelong Learning Institute. We're delighted that you could join us this morning. As you know, OLLI at Berkeley has had an ongoing series called America's Unfinished Work that features presentations by influential figures on campus and in our community that looks at and examines the issues that are in front of us around race and the issues around systemic racism and ways that we might move forward, perhaps with the eradication of racism. Today's talk will be given by Emerson Sykes, and it's called Bans on Inclusive Education, a First Amendment Fight. Emerson comes from the ACLU and is in a program at the ACLU called Speech, Privacy, and Technology Project. He earned his BA in political science at Stanford, which we're not holding against him, and a master's in public affairs at the Woodrow Wilson School at Princeton. His law degree is from NYU's School of Law. He has been an advisor in a variety of platforms in Africa. And it is, as you can tell, it's been a career that has spanned many public interest issues, including, let me just mention that you did serve as Assistant General Counsel of the New York City Council, and particularly during some of the hottest debates around stop and frisk. Emerson, we're really delighted to have you with us today, and the platform is all yours.
Thanks very much, Susan. It's a pleasure to be with you today. Let me go ahead and share my screen. Can you, Susan, give me a thumbs up if you can see that?
Yep.
Awesome, fantastic. Great. So it's a pleasure to be with you today. I wish I could be actually in California. I was there last week. I miss it dearly. But I'm here to talk a little bit about an issue that is in the front page of a lot of newspapers, the podcasts coming out about it. It's sort of everywhere we look, we hear talk about these bans on inclusive education and the sort of battle over how we teach history and our culture in public schools. So I know that there are no shortage of analysis and commentary on this trend, where it comes from and what's happening. But I'm here just to humbly offer my perspective as a First Amendment litigator working on some of these issues in federal court. So today I will cover a few things. I'll set the stage a bit for how I think we got here. I think it's really important how we start these conversations. I'll talk a little bit about the backlash against inclusive education, the ACLU's response, some new variants. More recently, we've seen this issue sort of develop in new and in tricky ways. And then I'll finish with what I think we can all do to try to push back against these efforts, and finish with Q&A. And look forward to hearing from you any sort of questions that this brings up. So let's set the stage a bit. So I think, you know, there are lots of places that we can start this story, but I think it's important to lay out, even though I'm coming to this issue as a First Amendment litigator, this goes far beyond any particular piece of litigation. This goes far beyond even the law and the legal system, and really goes to sort of a fundamental debate about who we are as a country and how we talk about our history, our myths, our stories, our national narrative. And if this dates back to the founding of the country, right? Who are we, and what is our origin story, and how are we in our road to progress? And so I think in some ways, this is very new. It's a new trend. It's something that we haven't seen before in exactly this way, but in other ways, it is some of the oldest debates that we've been having as a country. I think it's also important to note that after generations of having a whitewashed history in public schools, and explicitly and intentionally whitewashed history in public schools, we've made huge progress in the last few decades towards having a more inclusive and diverse curriculum that reflects different perspectives from different people that have been marginalized in previous versions of history, whether that be people of color, African Americans, Indigenous Americans, immigrants from all over the world and their impact on the United States, as well as, of course, the role of women, LGBTQ individuals, all sorts of stories that I think now are being included in American history courses, in reading lists, in curricula. I have a 4-year-old and a 7-year-old, and I am thrilled with how the breadth of information that our youth are being exposed to now that even when I was a kid, we were not. So I think that there has been massive amounts of progress. So even though it's depressing when we read the news and there's another fight in a school board, there's another teacher who's threatened with being fired, there's another kid who gets suspended, it can be very depressing. But I also sort of always frame this backlash as a reaction to the decades of progress, and I think over the last at least generation of progress in terms of building a more inclusive and progressive curriculum. And then I also think that it's important to sort of situate this not just as a legal question, but also as a part of a broader conversation about our public schools and how they fit into different political narratives. We've heard folks who are pushing for bans on inclusive education vilifying quote unquote critical race theory, but also linking that directly to trying to undermine the public school project more broadly, to privatize education and to increase access to vouchers. So this is one small piece of our national narrative, but it's also one small piece of a larger sort of political campaign being waged in different ways. But with all of that, I will focus in on some of the legal issues that are coming up because, as I said, I'm coming at this as a litigator. So I hate to even include this slide sometimes, but I think, as I said, this is the backlash. And what we saw was a guy named Chris Rufo, who had this idea about 2 years ago to create sort of critical race theory as a bucket into which he could dump everyone's racial anxieties, right? So he came up with this tagline, who I don't know how he happened upon such an effective piece of messaging, but it was largely his idea to weaponize critical race theory, which of course, is a particular legal school of thought that was developed in law schools in the last couple of decades, but has now been used intentionally by Chris Rufo and others to sort of embody anything that's related to anti-racism, wokeness, cancel culture, you name it. It sort of is a catch-all phrase, as I said, I think, for sort of generalized racial anxieties. And I think, the apocryphal perhaps story is that Chris Rufo went on Fox News and asked President Trump to issue an executive order banning critical race theory in trainings for public employees. And the next day, Trump issued Executive Order 13950 on combating race and stereotyping. And I think that executive order is no longer in force. President Biden withdrew it. It was ruled unconstitutional, at least in part, by the Ninth Circuit in a federal lawsuit brought by Lambda Legal. But one thing I think is worth noting about the executive order, even though it's no longer quote unquote good law, is it starts by quoting Martin Luther King. And this really set the tone. And this is something that we have seen throughout. In the briefs that I'm writing, often the government's reply brief in defense of one of these laws is opening with a quote from Martin Luther King about one day living in a society where we're not judged by the color of our skin. So this sort of, I don't even know what to call it, this sort of rhetorical gymnastics is sort of there from the very start. And it's irksome, and I think it's designed to be exactly that. I was able to work in a quote in one of my last briefs from Martin Luther King's daughter, basically saying like, how dare you use his quotes to support these kinds of ideas. And so what we've seen is the language from that executive order has been cut and pasted into lots and lots and lots and lots of state bills. And so this list of divisive concepts, it's been modified. Each bill is tweaked and redrafted and sent to the House and the Senate and sent back and redrafted and combined and whatever. There are several different versions out there, but there are these templates that are clearly being used and cut and pasted into lots and lots of state bills. I don't even include the number of bills because it's changing so much, but there's lots of tracking out there about, it's dozens and dozens of states have introduced these laws. Only about 10 of them have passed, I believe. But there are so many, and so many state legislatures have lots of bills pending, and the legislatures are in session right now. So now is the time to keep your eyes peeled for what's being passed in your state. As a litigator, we've been focusing a lot on these state laws, these statewide measures, because we think if we can challenge them, then we can have large impact on a statewide level. But most of the action, I would say, on these sort of anti-inclusive education initiatives are at the local level. So whether it's a local school board policy or a principal or in a particular PTA, we've seen that even in states where there is no law banning quote unquote CRT, we've still seen lots of backlash against those who are trying to teach a more inclusive curriculum. And I also should note, it's a related issue and it's often, grouped in because I think it very much is of a piece of this same issue, but there have also been a distinct rise in book bans. So removing books from school libraries and public libraries that relate to especially race and gender identity. So that's a slightly different legal issue, but it's certainly closely related and a part of this more general backlash. So what has the ACLU been doing? There have been lots and lots and lots and lots of organizations working in lots of different ways to try to push back against these things. But the ACLU, I think, has a particular role to play. I'll just mention before I get into the ACLU response, the main, I think, organizer around sort of all of the different kinds of coalitions that are working on this is the African American Policy Forum. And they've got working groups for academics, for artists, for educators, for litigators, which is one that I'm a part of, but they've got lots and lots of different, moving parts and coalition partners in different ways. So that's a key group to be aware of. And then in the legal sphere, the NAACP Legal Defense Fund and the Lawyers Committee for Civil Rights Under the Law have also been very active, as well as the Southern Poverty Law Center. But within the ACLU, for those who are not familiar with our structure, we have affiliates in all 50 states. We actually have 3 affiliates in California, one for NorCal, one for SoCal, and one for San Diego in the Imperial counties. And so each affiliate is largely independent. We work closely, and I'm in the national office. We work closely with affiliates, but they are independent entities and they make their own decisions about where they get involved and how. And then within the national organization, we have several different departments. We have communications, political advocacy, and legal. And our communications team has been trying to figure out through message testing and social media campaigns, how we can best talk about these issues, because they can be very thorny to talk about. And I think for just the initial example, the idea that CRT, critical race theory, has been sort of weaponized and co-opted to mean all sorts of different things. And how do we combat that messaging? And so we've talked about these bans on inclusive education, and also calling these laws education gag orders. So these are small things, but I think throughout this whole process, we've had to be very careful about, this is a public messaging issue as much as anything else. Our political advocacy team includes organizers, it includes campaigners, it includes legislative advocates. And then for my team, which is legal, and we're divided up into several different teams. So I work on the First Amendment team, we call the Speech, Privacy, and Technology Project, but we're also working hand in hand with our racial justice team on these sets of cases. And we've been tracking these laws in dozens of states and have filed 3 lawsuits recently. One is a case that I'm the co-lead attorney on, which is Burt v. O'Connor, challenging Oklahoma's HB 1775. So I'll talk a little bit more about that case in particular, but also wanted to mention Mejia v. Edelblut, which is a challenge in New Hampshire that we're a part of, to their ban on inclusive education. And then also relatedly, the ACLU of Missouri is representing a student in Wentzville, Missouri, about a book ban in their school. Several books by Black and LGBTQ authors were removed from the school library. But as I said, I want to focus in on that first case, which is Burt v. O'Connor. So HB 1775, we picked HB 1775 as the first federal lawsuit that we wanted to file challenging one of these education gag orders. So why did we choose this law? It applies to both K-12 as well as higher education. So some of these laws apply only to K-12 education. Some of them apply only to higher ed. Some of them apply only to government contractors. But HB 1775 in Oklahoma was one of the few of the early laws that applied both to K-12 and to higher ed. And as you may know, the First Amendment provides special protections for higher education. This idea of academic freedom, where our colleges and universities are supposed to be the breeding grounds for new ideas and the vibrancy of our democracy. So there are special protections against efforts by legislatures to dictate what can and can't be taught in higher ed. But it also features that same list of 8 prohibited concepts from the Trump executive order. And I think, I didn't include all of them here. You've probably seen them, but some are seemingly innocuous. They basically say, like, don't teach that one race is better than another. And then some are totally nonsensical. There's one that says, and I always forget exactly how it's worded, but it says that it's prohibited to to include in any course that members of one race or sex cannot and should not attempt to treat others without respect to race or sex, which I had to pull it out and read it because I've read it hundreds of times and I have no idea what it means. So some of these provisions of these laws are so sloppily written that they're actually nonsensical. And then others are extremely broad and sweep in the mere discussion of issues that regard race and or sex. And so I think these laws have been written intentionally broadly because they want them to apply to lots of different speech and to have a chilling effect on teachers and professors. And so we decided that the story that we could tell in Oklahoma was particularly compelling. And because of these features, the fact that it included this template that so many other states have adopted. So we think if we can get a positive ruling in our lawsuit, it can have much wider impact. But here's a little bit about the details of the lawsuit. We brought 4 different claims, 4 different legal claims. One is a vagueness claim, which is really a due process claim. So it's actually independent of the substance of the law. We argue that it is impermissibly vague. That is that the people who are subject to the law, in this case, teachers whose licenses are on the line, cannot reasonably be expected to understand what is permitted and what is prohibited because it's so vaguely written. So that is one of our claims. Then we have 2 First Amendment claims. One is about the academic freedom protections in higher education that I just mentioned. And the second is about the right to receive information. So the First Amendment not only protects the right to speak, but it also protects the right of students to receive an education. And here actually there is significant deference that states have to craft their own curriculum. It inherently has to make some choices about what to include and what not to include. And judges are generally hesitant to weigh in on, state education officials' choices about their curriculum. But the First Amendment protects the right to receive information where there is no reasonable relationship to a legitimate pedagogical interest. So again, a reasonable relationship to a legitimate pedagogical interest. It shouldn't be that hard to satisfy. But here, what we have is legislators going against what are in the state standards, which is to provide a diverse and inclusive and comprehensive story about American history and to include different perspectives, going contrary to all of the educational research that says that inclusive education improves students' understanding, it improves their behavior, and it improves their academic performance, and going far in the other direction to prohibit the discussion of race and gender in the classroom. And so we think that these legislative efforts, and particularly HB 1775, fails even this low bar. And so I think, actually, sorry, this is the 8 prohibited contents again, but so we had 4 claims. We have about 28 defendants. They include the state attorney general, the governor, the State Board of Regents, the State Board of Education, as well as the Oklahoma University Board of Regents, and an individual school district, Edmond Public Schools. And we included OU and EPS, Edmond Public School, because the 2 sort of smoking gun, so to speak, enforcement actions that we think merited bringing a lawsuit were that a professor at Oklahoma University was told that they could not test on critical race theory, and Edmond Public Schools created a slide deck for their teachers in sort of saying, okay, this is how you need to implement HB 1775. And they told teachers to avoid the words diversity and white privilege. And so we argue that these sorts of, the way the law is written, it is so broad and vague that it leaves folks with no choice but to censor themselves and to avoid any discussion at all of these controversial issues. So I just want to say a little bit about our lead plaintiff, which is the Black Emergency Response Team. So they were a student group. They are a student group at Oklahoma University. They were formed in response to a racist incident that happened on campus. They held protests. They occupied campus buildings. They created a list of demands. They met with administration officials. They did press conferences. They held marches. They did all the things that student activists do. They came up with a list of demands, and among their list of demands was that there should be a course for all oncoming students on diversity to try to establish some norms about how we're going to live together in our heterogeneous community. And this was successful. Through their advocacy, the university adopted a new course that would cover issues of, diversity on campus. We think we have every reason to believe that it was specifically in response to the successful advocacy of the Black Emergency Response Team that, I'll go back, there was a specific prohibition on any orientation or requirement that presents any form of race or sex stereotyping or bias in Oklahoma public colleges or universities. So what they were trying to prohibit here was the required course that BERT successfully advocated for. But what they ended up doing is banning any requirement, including any required course, from merely presenting any form of race stereotyping or bias, with no carve out for merely presenting in order to criticize, right? So you cannot discuss these things in any way in any required course at Oklahoma University, which is of course a dramatically impermissible infringement on academic freedom. So we have Black Emergency Response Team is our lead plaintiff, but we have 7 different plaintiffs. We have BERT, we have the American Association of University Professors, AAUP at Oklahoma University. We have the NAACP of Oklahoma, the American Indian Movement of Indian Territory, 2 educators, 1 Black, 1 white, and 1 Black student from Oklahoma. And so we think that, the enforcement actions that we just mentioned at Oklahoma University and by the Edmond Public School have created a really compelling story for why these laws are so dangerous and why it's imperative that a federal judge rule them unconstitutional as soon as possible. So we have filed, we have finished our briefing in that case for now, and we are literally, sort of waiting to hear if the judge is going to enjoin the law while the lawsuit proceeds. So we'll see where that goes, but it could happen anytime. So I'll just move from talking about that specific lawsuit to a little bit more about, oh, sorry, I should say that that lawsuit is filed by the ACLU National Office, along with the ACLU of Oklahoma, the Lawyers Committee on Civil Rights and the Law, and our pro bono counsel at Schulte, Roth, and Zabel. So what are we seeing now? We're seeing that in state legislatures, I mentioned that a lot of the legislatures are in session as we speak. And so we're seeing some evolution in these laws. One is that some of them now have specific carve-outs or narrowing provisions, unlike the law in Oklahoma that say, nothing in this bill should be understood to limit discussion of race or sex generally, or of slavery, or of other things that may be difficult in our history. So we have seen some of those attempts to sort of create those carve-outs. Usually the rest of the law is still so problematic that these carve-outs don't actually accomplish a lot, but we have started to see some of these attempts at narrowing provisions. Another development we've seen are these curricular transparency bills. So this is actually something I mentioned Chris Rufo earlier. He actually tweeted very explicitly, he said, look, we all know that these bans on CRT are probably unconstitutional. So now we're going to pivot to transparency bills, and we're going to just make it about access. And we're going to, make the progressives seem really silly because we're going to make them look like they're against transparency. And it's been a clever bit of messaging. And I think, as far as the ACLU is concerned, we are now and have always been in favor of transparency. We do as much federal FOIA litigation, Freedom of Information litigation, I think, as anybody. And even in education, we think that giving parents the right to access what's being taught in schools is really important, and something that is largely being done in many places, and we support those efforts. What we're seeing now are these efforts to sort of create witch hunts. So passed in conjunction, there may be called transparency bills, but the ones that we're worried about are the ones where there is a list of broad, vague, banned concepts, which include penalties that run directly to teachers and include complaint mechanisms that allow any parent to launch an investigation that may have, immediate action just from the creation of the claim, and create these onerous requirements that educators pre-clear everything to all parents and give individual parents veto power over the curriculum. There's a long-standing practice that if a parent wants to, opt out, especially of sort of sex ed or that kind of thing, parents already have a long-standing right to opt out of that kind of thing. What these laws are trying to do is to make one parent have veto power over having any sort of anti-racist ideas presented to any of the children. Another thing we're seeing is requirements around teaching patriotism and some sort of formulation of saying you're not allowed to denigrate sort of the immaculate founding of our country in any way, which we think we haven't filed suit on one of those yet, but we think they're deeply problematic. And I think we're also seeing head-on attacks on academic freedom. I think it was the Attorney General of Texas last week said he was going to propose that all tenure should be done away with because of sort of the impact that CRT was having at the University of Texas, Austin. So, I mean, the idea that this was going to be limited in some way to a certain subset of trainings that might be a little bit cringeworthy, we think was always sort of a misconception. This is really an attack on public schools and an attack on academic freedom and an attempt to sort of re-whitewash how we talk about and think about our history and our present day. So, sorry. What can we do? I think, there are a few things that I think everybody can do. As I said, what I'm doing is filing federal litigation to try to stop these bills in their tracks and try to make sure that other legislators know that that they are not allowed to pass these types of bills. But that's one very small piece of all that needs to be done to try to move us forward as a society on these crucial issues. So one thing is that you can tell your school board how you feel. There are lots of folks who are screaming very loudly in school board meetings. You can engage how you feel most comfortable, and that may be an email, it may be a tweet, it may be some sort of formal submission. But I do encourage you to make sure your school board and your local officials do know how you feel about these issues. I think one of the things that we have seen time and time again is that as much as these are big political debates about sort of the role of racism in our institutions, it really is the teachers who are squeezed in the middle. I'm the husband and son of teachers, and I think one thing that we can do is just support the educators in our lives, ask if they need help, if there's anything they need, if they need supplies for their classroom, whatever it might be, or just an ear to sort of vent about how they're sort of really being caught between a rock and a hard place, because they're trying to do what's best for their students and provide them with an age appropriate and inclusive understanding of the world around them, while also on the other side being very worried about what's going to happen if a parent lodges a complaint. And this, I can say, is happening not just in red states or in places that have these laws in place, but within my own neighborhood in Brooklyn. And I think the last thing I would just say is there are I mentioned a few of the coalitions and the organizations that have been active on these issues, but there are lots and lots and lots of local and national coalitions to protect educational integrity. And I think you can pretty easily find something in your area. So I encourage you, if you're so moved, to join one of those groups. So I think I said I would be at about 30 minutes. Susan, I'm exactly 30 minutes about. So can we open up for Q&A maybe?
Absolutely. And as we wait for questions to come in, let me just say, Emerson, thank you very much. This is such important work, and it's reminding me so much of my days as the state's arts advocate during Jesse Helms' attack on the arts, that took place. It was trying to undermine federal funding for the arts, and how much it was important to understand those attacks as freedom of expression issues. I know for myself, I'm a member of the Southern Poverty Law Center and receive their material, and I imagine many members are, as well as the ACLU. So thank you for those, for the call out for those organizations. And we may gather that again from you, just so that we can post it with the video of this talk so that people know how to get involved. It sounded to me as if there is a movement of placing more conservative voices on school boards. And I'm also thinking, do you have a sense of what is happening in California, both with that effort on school boards, and then if there is any other legislation that concerns you right now?
Yeah, I mean, there's definitely, as I said, a lot, while we've been focusing on statewide laws, a lot of the action is at the school board level and the school district level. And I think there has been a long game. There is a slide deck. There are several slide decks that cover sort of what to do to root out CRT in your schools and that kind of thing. And one of the slides is go to a school board meeting and raise a ruckus, which we've all seen the videos from Loudoun County and other places where that is being done. One of them is to join the PTA and find the diversity and equity committee and run it off the rails, which happened in my own kids' PTA. One of them is find out every single book that's in the library and see if any of them are on this list of sort of watch books for anti-racism and wokeness and whatever else, what other labels are put on these sort of undesirable viewpoints. And I think one of them is also, sort of run for school board. And I think that has been a playbook that has been used. But I think there's also, in some ways it's backlash against progressive school boards in many places as well. So, that has been an area that a lot of groups have also been prioritizing is, these are elected positions, and therefore you can put forward candidates who support ideas that you like, and you can hope that they win. But I think, in terms of what's going on in California, I'm not aware of much on the statewide level, but this has come up in many school boards. It's at least an issue of discussion. And I think, as I said, there are ACLU affiliates all throughout California. So if you're aware of something that happens in your local school board, in your local school district, I encourage you to reach out to them specifically. But I don't know of anything specific in California at the moment, other than I believe Davis actually recently had both an anti-CRT bill before them, built on this same template that I was discussing, and sort of a progressive education bill, which would sort of, underscore the importance of having a variety of perspective reflected in the curriculum. And they sort of went head to head, and the progressive bill is moving forward, and the other one was rejected. So it's, from my perspective, a bit of good news out of California.
Very good. Matthew Pavoni asked the question, can you define what you understand critical race theory to truly encompass? And let me just say, we did have an entire talk with a law school professor here at Berkeley, Kiara Bridges, that is available on Ollie's YouTube site, that is on critical race theory and explaining what it is. But for the moment, Emerson, can you give your quick definition?
Sure. I mean, I was just on a podcast with Professor Bridges and Professor Kim Crenshaw, who was one of the sort of founders of critical race theory. And I think what she would say is that it's an approach that acknowledges that racism is not simply a matter of individual bias, but that it can be seen in the institutional and the systemic racism throughout the legal system and other institutions. So I think it's a sort of framework of analysis that seeks to acknowledge the hidden ways in which race impacts the seemingly race neutral or non-racialized decision-making about sort of which crimes are prioritized, what kinds of interactions law enforcement have with communities, all these sorts of questions that may not explicitly be about race, but that we can see the sort of impact of racial hierarchy in our institutions in that way. So I think, it's important. It's not in no way, when we talk about sort of rejecting this label, it is in no way sort of discounting the importance of this contribution to the legal field and beyond the legal field. It has had widespread impact. But truthfully speaking, like Kim Crenshaw's legal texts are not being taught in K-12 schools. I think it's true that an effort towards acknowledging intersectionality, which is another thing that Kim Crenshaw was sort of the coiner of, I think they have had impact on K-12 curriculum in a positive way. But that's why you'll often hear people say, well, CRT isn't even being taught in K-12, which in some ways is true, but it's also not to run away from the widespread impact that these sorts of ideas have had in different fora.
Great. The next question we have comes from Brian Murphy. And I think you had mentioned in the HB 1775, that you had involvement from higher ed. But his general question is, have you received important assistance from universities? Are they co-litigants or have they filed supporting briefs in these cases? So maybe just underscore what's happened with HB 1775, but also, are you seeing it as a possible source of support in some of this litigation?
It's a very interesting question. In fact, Oklahoma University and the State Board of Regents are involved in our lawsuit, but as defendants, we have sued them. They're not very happy about it. The university basically has said, your fight is not with us. We didn't pass this law. We haven't done anything to implement this law. And to the extent that we have done anything or made any changes or canceled anything, it's totally within our discretion to do so. So they are basically trying to wash their hands of this altogether and say the fight is not with us. But the reason that we think they're implicated is because the impact is not just being felt in the legislature or in the state board, but it's on campus. And we think creating or showing that direct link to deans and other university administrators giving advice to professors to limit what they teach in reaction to this law is a key piece of this story. So we continue to think it's important to have OU in as an enforcer of this law and as a defendant of this law, even though the truth is that many within Oklahoma University, we're not supporters of this law. They came out against it when it was drafted, but now that it's a part of the law, they are a part of the government. It's kind of an interesting situation of public universities as sort of government entities, but definitely very different from most government entities. So I think they wish that we had not found them to be so directly implicated, but we think that the universities are. And so as I said, the AAUP is our client, and we are co-counsel with the AAUP in New Hampshire. So we have been working closely with different kinds of campus-based groups, but universities themselves are more often the subject of our lawsuits rather than our co-counsel or co-litigants.
Interesting, thank you. Any other follow-up questions on that? Okay, all right. Brian is raising his hand. Could you, I'm going to unmute him. Brian?
Hi, thank you, Emerson, for the presentation. It's really very helpful. The reason I asked about whether you had any supporting briefs from universities, and I suppose to widen the range from Oklahoma, there has been I think a political tension in most university leadership between their opposition to censorship laws when they're passed in other states and precisely the dynamic you're talking about, principally around anxiety regarding their budgets. If I oppose this specific piece of legislation from a majority party, Republican Party specifically, will I be punished? So I was wondering whether or not in your larger national work, you have found any, I can put it bluntly, any universities prepared to stand up publicly to say this stuff is outrageous and should not pass.
Yeah, I mean, I think there have been a few that have been outspoken. I mean, what you mentioned brings to mind Wyoming, where there have been efforts by the legislature to defund the gender studies department. I believe that's Wyoming. It's sometimes hard to keep straight all the different things that are going on around the country. But you're exactly right. Those fears are legitimate. If you get on the wrong side of the legislature, your department might literally be on the chopping block. So I think, we have seen universities, including, as I said, the Oklahoma University, come out against these bills. But once they're enforced, they're in a very hard position because actually, it's very hard for the university to sue it's very hard once it's the law for a government entity to then challenge it. But we have seen, individual administrators and even university as a whole come out against the draft bills. And I see a question about private schools. It's a great question. So here, I mean, the First Amendment is only about government efforts to restrict private speech, right? So this is why Twitter is not covered by the First Amendment, or actually Twitter is protected by the First Amendment and other sort of private social media companies. The First Amendment is primarily worried about government censors, right? So the First Amendment in general doesn't apply to private schools, right? Because private schools can set all sorts of limitations that public schools can't, because they're private entities and they get to decide what they do and don't want to do. And no one else is really necessarily impacted by the choices that they make, because you can either choose to become a part of this group or not. So in general, private schools are not bound by the First Amendment, and private universities are not either, even though public universities and public schools, for the purposes of the First Amendment, are considered the government. There's a slight caveat to that, though, because you're talking about California specific issues. It's called, now the name is going to escape me, but there's a law in California that basically says that the First Amendment applies to private universities as well in California. So I think it's the only state with such a provision. So in California, the First Amendment does apply to private universities. I don't believe that extends to private K-12 though. So private schools are largely left out of this. And as I said, this is a part of the larger narrative of trying to make public schools sort of unworkable in order to empower the shift to private schools. And this is, reminiscent of what we saw after or in the early stages of desegregation, where, private schools were flooded with folks who were trying to flee the public school system for fear of being exposed to too many different kinds of folks.
Interesting. Brian, question for you. Does the master plan for higher education, is it the legislation that brings in the First Amendment to higher education for the privates?
No, it doesn't, insofar as the master plan governs public institutions. And frankly, when it was drafted, I think the general point that Emerson's made is really important to emphasize. It was so much atmospheric, it was so much understood that these institutions had the authority to determine their own curricula, that the master plan doesn't detail academic freedom other than reference it. It's an important element of what everybody understands education to be about, and specifically higher education to be about insofar as it offers tenure to faculty to support them. So there is legislation protecting tenure, and that references, at least in California, the freedom of an individual once granted tenure to hold views that are unpopular and to be protected in the holding of those views, and sort of by definition, the teaching of those views. But it does not govern private institutions just exactly the way Emerson's talking about it. There is, I think, though, Emerson, with at least private higher education, there are federal laws governing the use of federal monies that would provide leverage, if I can put it that way, if an institution chooses to teach racism or chooses to teach segregation. It's why colleges like Hillside College, a very, very reactionary private college, refuses all federal aid, assistance, including financial aid, because they don't want to run afoul of equal protection codicils, I think.
Yeah, no, I mean, it's called Leonard Law. I forgot, it's from 1992, but that's the one that applies the First Amendment to higher education. But I mean, the fact that you brought up the funding, Brian, is important. I think there are different rules for what the government can attach as conditions to its own money, because that's considered government speech, right? So it doesn't have to be as fair and balanced in its doling out of money as it does when it's having to tolerate people's commentary on what the government has done. So we've seen a lot of these laws actually that I was talking about. One move was to limit them to to government officials, to training of government officials, which, there is no real First Amendment argument around sort of how the government trains its own employees. But I think that bit of restraint was short-lived, and what we've seen now is very much a focus on schools and now on universities as well.
Mm. Emerson, do you see as a part of the larger legislative agenda nationwide, parents being able to sue teachers? As we've seen in the abortion issue, where individuals can sue against abortion providers or other entities.
Yeah, I should have put that in my new variants, but that was part of it, is these like private rights of action, right? So what we've seen is like sort of this suite of bills, which is banning these concepts, creating, trying to create quote unquote transparency, but then also with these private rights of action. So then you can really have one person sort of, be the instigate these investigations, bring the claims on their own behalf, and potentially have devastating impacts not only on the quality of the education, but also an educator's livelihood and career, with just a complaint. I mean, we've seen some of these boards start to function. We've certainly seen the chilling effect in lots of places. We've seen teachers threatened with removal in many places. But a lot of these are still sort of in the early stages of being stood up as sort of complaint mechanisms. I know that at least one state recently said that they had received 2 or 3 complaints, but found them to be not of merit and sort of moved on, but not in entirely convincing ways. They sort of found them to be without merit because the school had ceased the policy in any case or something like that. So we are keeping our eye out for these efforts to sort of deputize individual parents to police the curriculum of their schools, which I think is different than providing transparency and an opt-out option.
Yes, thank you. Have you been approached by students to make the argument that they are denied education by a bill like this?
Of course, yeah, that's our third claim, is the right to receive information. So that's, I think, the first claim, the vagueness claim, is really on behalf of teachers, because it says you can't be expected to, understand what this law says, and if you violate it, you will lose your teaching license. So the vagueness claim is on behalf of teachers. The higher education claim is on behalf of university professors and university students. But the third claim is around the right to receive information, and that's on behalf of both K-12 students and higher education students, because the Ninth Circuit in particular has found that there is a specific right to receive an education free of partisan and political influence, and we seek to vindicate that in our case, definitely.
Great.
And our organizational plaintiffs, like the NAACP and the American Indian Movement, are actually on behalf of their members who are teachers and students in Oklahoma public schools.
Great. I think we have time for a couple more questions, and we've got another one from Matthew Ovoni asking if the law has been stronger on book banning because of ACLU's efforts.
Well, we're relying directly on that case law. So there are a handful of key cases, and this particular issue has not yet come before the Supreme Court. So there are a handful of cases that we think are important. There's PICO, which is about removing books from school libraries. And that's where we get this ban on political or partisan, purely political or partisan interests. Some courts have applied, have said sort of PICO is limited to the library context, and others have applied it more broadly. But that's why I said that the book bans are a slightly separate line of cases, because they rely directly on PICO, and it sets quite a high bar. There are also these cases around, there's a famous case called Hazelwood, where it was about a school newspaper. And so the question there was whether it's when something sort of bears the imprint of the school and appears to be an official publication, even if it's written by students, then the school can exercise its editorial power, right? So the idea there is that the First Amendment doesn't necessarily protect student speech within a context of a school newspaper or some other school-sponsored, speech. that is associated with the school, with the imprimatur of the school. There's another case about giving a talk during a school assembly, and whether or not you can use profanity and explicit language during a school assembly. There's another one about holding a sign at a march outside school that advocates the use of drugs. And basically, the Supreme Court has said you can limit the use of the talk about drugs. You can limit sexually explicit language in a public forum, in an auditorium, and a school can regulate the content of its own school newspaper. And the regulation of the school newspaper is the one that has most often been used as analogous to curricular decisions, right? Because what the school teaches, what's their curriculum, is essentially the school's own calculations about how it wants to conduct itself, if that makes sense.
I believe it does. And we've got one more question, and it's that return to the private rights of action. Can you comment on the legality and the effect of these types of laws on society overall?
I mean, it's important. I mean, I'm not an expert in the sort of history of private rights of action, so I hesitate to make too many generalizations. But I think, one could imagine situations where there are particular kinds of laws where it might be very important to have different kinds of community engagement on enforcement. But I think what we're seeing here is explicitly with SB 8 in Texas around abortion, the efforts to make an unconstitutional law constitutional by making it a private right of action rather than a government entity that is enforcing, right? So I talked about how the First Amendment is really about limiting what the government can do to silence private speech. So if the government is simply opening the door for other private actors to silence private speech, there's some idea that they can sort of do a constitutional two-step and get around that by creating these private rights of action. I don't think they should be able to get away with that in particular. I don't know if that means that there should never be any private rights of action ever for anything. That may be true, but I'm not sure. But I can say that what we're seeing it used here is to try to sort of make something unconstitutional constitutional, which I don't think they should be able to get away with.
And since we have with Citizens United and others with corporations being regarded as individuals, would that give them private rights access as well?
It's a good question. I mean, the Citizens United was infamously maybe or famously an ACLU case. We have some unpopular views on Citizens United in general as an institution that I won't defend here. Yeah, I mean, it is hugely problematic, the extent to which there is an explicit attempt to empower folks to scare teachers from talking. And what is a reasonable teacher going to do, despite the fact that the best interests of their students are front of mind? There is going to be an impulse to withdraw and to not cover topics that you would otherwise cover because of a fear of backlash. And I think that that's really sort of the tragic part of the story.
Emerson, thank you so much for the talk. We are now at the end. Is there any final remark you'd like to make?
Yeah, I can't end with just the tragic part of the story, right? Like, no, I think we are, the strength is in the numbers, right? And I think that there are tons of opportunities and a really strong coalition that's come together to try to push back against these efforts. I will acknowledge that we've been caught a bit on the back foot. No one really expected CRT to sort of catch fire like it did and become such a successful talking point for so many, and we expect it to only grow to be more in the sort of elections in the fall. But better late than never. And I think what we have seen is a really wide-ranging coalition and lots of sort of interaction between different groups who are trying their best to do their part to sort of make sure that we protect our kids' right to a comprehensive and inclusive education. And thank you very much to whoever it is that this just joined the ACLU.
And that is true of OLLI members. They're very interested not only in learning the latest, but also becoming engaged. Thank you, Emerson, and thank you all for joining us on this Friday morning.
Thanks so much for having me.
Thank you.